Compliance and Regulatory webinar series. We'll discuss the latest in news regarding the complicated and constantly changing regulatory environment that affects all of us in the contact center industry. We have all of the compliance webinars for 2019 listed on the PACE website, and we will be updating them with further details as they become available. As we prepare to start the webinar, we wanted to remind you of a few housekeeping items. All participant lines are on mute. If you'd like to ask a question, please do so in the chat box on the right-hand side of your screen. We will get to as many of those questions as possible during the last 10 to 15 minutes of our time today. This webinar is being recorded, and the recording of this webinar will be available on the PACE website in a few days. If you would like to receive the slides from today's webinar, please send me an email at chris.haerich@paceassociation.org, and I'll be happy to send them to you. Without further ado, I'd like to introduce the panelists for today's webinar. First, we have Michelle Schuster, and Michelle is the founding partner of McMurray & Schuster, where she brings extensive experience in working with clients of all sizes involved in highly regulated industries. She has established a solid record of representing clients in consumer protection matters before state attorneys general, the FTC, and FCC, in addition to conducting regulatory compliance audits and providing counsel on advertising and privacy issues. Michelle currently serves as General Counsel to PACE and oversees our self-regulatory organization program. In this role, and with her significant depth of experience related to TCPA compliance, she has been an integral part of PACE's current challenge to the FCC's TCPA order. She has an exceptional foundation in U.S. privacy laws and regulations and is accredited as both a certified information privacy professional through the International Association of Privacy Professionals and Customer Engagement Compliance Professional, or our CECP, through PACE. And Chad Blackman. Chad is an associate attorney at McMurray & Schuster, where he works with businesses in highly regulated industries, including teleservices, financial services, and medical marijuana. He helps clients understand and proactively manage compliance with federal and state consumer protection and privacy laws, and has assisted with litigation and defense of government enforcement actions by the Consumer Financial Protection Bureau and the Federal Communications Commission. I'm going to now go ahead and turn the floor over to Michelle and Chad.
Thanks, Chris, and good morning or good afternoon, I guess, depending upon what side of the country you're on today. Thanks for joining us today. I'll tell you, this is a presentation that has been requested by a number of PACE members and a number of clients and others in the teleservices industry. The legalization of marijuana, both for medical and for recreational use in various states throughout the country, has posed a number of issues for employers, and especially those employers that are in our contact center industry. We thought that this would be a good time to have a presentation that will explore what some of those issues are and provide recommendations for maybe some things that you can do to help eliminate some of the risks that as a call center operator you could be facing. I will say, as we always say with the webinars that we provide, this is a general topic webinar. It's not intended to give specific legal advice, and if you have those types of questions, you should most certainly consult with your attorneys to ask those specific legal questions. As we're framing the issues that we're going to be talking about today, there are some statistics that are kind of staggering and interesting and help to put a little bit of color on how prevalent these types of questions are. First, interesting to know that over the last 25 years that marijuana production has increased tenfold. I think that we will see as we're moving forward that that statistic is going to increase at a much more rapid pace as states begin to legalize marijuana use. Also, next to alcohol, marijuana is the second most frequently found substance in drivers involved in fatal car accidents. Now, while that statistic has to do with car accidents, it can certainly translate to the workplace as well and types of accidents that could occur there. For instance, for industrial accidents, employees who have tested positive for marijuana have a 55% increased likelihood of having an industrial accident and 75% higher absenteeism. So there is definitely a correlation between marijuana usage and the ability to perform and how that can affect those types of things. That said, we have statistics that show that 1.2 million authorized users of medical marijuana were in existence in the United States as of this year. I think that statistic is probably low. I think that that is a significantly larger number as states come online with approving medical marijuana. I can tell you also that our firm has gotten involved in the cannabis and the medical marijuana discussion as a result of Ohio becoming one of the states that has approved medical marijuana for usage. And you'll see as states come online with approving the use of medical marijuana that there are registration regimes that come into place for the companies that are involved with either producing or distributing medical marijuana. So that's largely where our involvement has come in, and now also on the employment side of things. So we have a really interesting presentation today. You are going to really enjoy hearing what Chad Blackham has to say about the HR implications of medical marijuana and kind of where the industry is going. It's a fascinating topic and something that all of us will be dealing with as we move forward. So with that, Chad, the floor is all yours.
All right. Well, thank you very much for that wonderful introduction, Michelle, and thank you, Pace, for hosting this webinar and having us on. It's really a thrill to talk about this area. Medical marijuana is unique as far as the issues that employers will face goes. The field is very new, and as I'm sure many of you are aware, it is federally illegal. I cannot think of too many things that you are going to have to deal with that are illegal, but nonetheless, you will have to confront them on maybe a daily basis. So we are going to start off with just a bit of a general discussion about medical marijuana, what it is, how it functions, and how it's different from what you might consider normal marijuana. So what exactly is medical marijuana? Well, for all intents and purposes, medical marijuana is normal marijuana, albeit with greater oversight and regulation. The chemical composition of marijuana is derived from what are called cannabinoids. There are approximately 113 different cannabinoids within the marijuana plant, and they all have a very complex interdependent mixture, and they all have synergistic effects. You take one out, the others become weaker, and vice versa. Now, don't worry, we won't be talking about all 113 of these now, but there are a couple, THC and CBD, that we will get to very shortly. The chemical composition of medical marijuana, additionally, is going to differ from recreational marijuana a little bit. For all intents and purposes, medical marijuana will be stronger than recreational marijuana. And in states such as California, where they have recreational and medical regimes, that's kind of the distinction there. That's what having a medical card and being a medical card holder will get you versus typical recreational marijuana. So it's important to realize that if you have a medical marijuana policy, it may be worth applying that towards recreational users as well, who will have access to lower THC content. So let's talk a little bit about the forms of administration. Now, this is a little unusual. Most people look at marijuana and they consider it, well, you smoke it. It's a very common subject. A lot of people understand it intuitively almost. Interestingly enough, states like Ohio and Florida, which I know a lot of our members operate out of, prohibit smoking marijuana, and they explicitly forbid it. So you may be asking, well, if people can't smoke it, how are they supposed to use it? The most popular forms of administration are going to be vaporization, which uses a form of convection heating as opposed to burning the materials themselves. Now, the belief is this is a little bit holistically healthier. It's kind of the distinction you see with e-cigarettes versus cigarettes. There haven't been too many studies on this, though, due to the federally illegal status of marijuana, so we're still holding out to see what the results look like. Other forms of administration include edibles, which I'm sure a lot of people will be familiar with. These are the things you will see in advertisements and that are very explicitly listed in state statutes and that a lot of state legislatures will talk about. You will also see oils and tinctures, which can be used as a topical salve or can be dropped on your tongue, but more often than not, these will be used for CBD products, which we will talk about shortly. So what is the difference between recreational and medical marijuana? Well, I talked a little bit about it. Medical marijuana is stronger. Notably so in that high THC marijuana, medical marijuana, can go up to 30% THC yield. If you look at the marijuana that was around back in the 70s, the average THC yield of that marijuana was 10%. So medical marijuana nowadays is approximately 300 times more potent than marijuana back approximately 40 years ago. So there is a distinction here, not necessarily of just type, but of pretty severe degree, in that medical marijuana will have much more powerful effects than recreational. So I mentioned a bit earlier about the 113 different cannabinoids in the marijuana plant. Cannabinoids are a very complicated substance, and the reason that they interact with human beings is we have these receptors in our brains specifically formatted for them like a lock and key method. And one of my favorite facts to kind of reiterate is that dogs similarly have this exact same receptor, whereas cats do not, which is okay because I've always been more of a dog person anyway, I suppose. So THC is tetrahydrocannabidiol. This is the compound most commonly associated with a marijuana plant. THC, in all colloquial respects, is what gets the user high and provides them a psychoactive effect. It can also help with increasing appetite, decreasing anxiety in certain individuals, and reducing pain. As Michelle noted in her opening statistics, however, this is also the compound associated with reduced reaction time and reduced ability to respond to change. In contrast to to THC, we have CBD, which is cannabidiol. Now, we'll be discussing CBD in greater detail later because this is something that a lot of people have been asking about very specifically, almost more so than medical marijuana, I would say. A lot of people are interested in what CBD can bring to the table. And so what I will say for the time being is that cannabidiol does not contain the psychoactive effects of the rest of the marijuana plant. An individual, for all intents and purposes, ostensibly taking a 100% CBD solution would not experience any psychoactive effects whatsoever. And this is something we'll discuss later, but this is something you may want to consider when drafting an employment policy around medical marijuana, the distinction between THC and CBD. Now, it's also important to note that regardless of which product you're going to get, because of the synergistic effects of the cannabinoids, any THC-based marijuana product or any CBD-based marijuana product is going to have a little bit of the other chemical in it. The cutoff for a lot of state regimes, such as Ohio and New York, is that CBD products must have 0.3% or less THC, which is a very minuscule amount and will not get the user a psychoactive effect where they're using a traditional THC-based product. But as we'll see later, because of the way marijuana functions and interacts with the human body, this is something to be aware of. So you'll see here we have a beautiful McMurray-Schuster 50-state survey. I apologize, it is slightly outdated. You'll notice Nevada is currently listed as white, which meant pending legislation, but they now have a recreational regime. So if everyone could take a moment to kind of find your state and determine whether you are recreational medical use or no enacted legislation. We'll talk about it shortly, but this is the first starting point to determining what you want to do with medical marijuana in your workplace. All right, so now that we have looked at what states allow it, what don't, let's talk a bit about the different types of regimes. So, pro-employer regimes, which I'm sure everyone here is probably going to be very interested in. What makes one of these regimes pro-employer? How do you determine if your system is for the employee versus the employer with regards to medical marijuana? Well, with pro-employer situations, we typically have express statutory language. Now what this means is you'll have a specific code citation that you could look up in the medical marijuana statute, and it will say, hey, you the employer, you are allowed to fire, hire, discharge, terminate, whatever you want to call it, an employee based on medical marijuana usage. The majority of pro-employer states have such language and explicitly enumerate what you are allowed to do with medical marijuana in your workplace. Now, just because there's express statutory language doesn't make it clear-cut, however, and there are a lot of small idiosyncrasies that can get lost in the gray areas of these clauses. A lot of these medical marijuana regimes, especially in Ohio, in my point of view, were kind of rushed through and didn't really have the full fleshed out statutory analysis you might see in bigger laws, such as the TCPA, which I'm sure everyone is also very familiar with here. So just because that language is in there is helpful, but it is not the end-all be-all. The next bullet point here, freedom in creating employment policies. So when I say a state is pro-employer and that there's express statutory language, it's not simply that the statute says you can do whatever you want. More often than not, and in a majority of pro-employer states, what you are allowed to do is first dictated by your employment policy. And in fact, in Ohio, for instance, the express statutory language giving you the ability to make termination or hiring decisions based on marijuana use comes from your employment policy. We'll talk about employment policies specifically later, and you'll hear me say this probably over and over ad nauseum, but I want you to hear it until you are tired of it and bored of it and know it like the back of your hand. But your employment policy is the single most important thing that you have with regards to medical marijuana use in your workplace, of course, besides the laws. This is where all of your leeway, all of your constraints, and all of your abilities will really stem from. So it is incredibly important to have a clear, concise, and readily available employment policy that specifically addresses the issue of medical marijuana in your workplace. Now, the final bullet point here, just cause discharge. The majority of pro-employer states provide that if an individual is prohibited from using medical marijuana pursuant to their employer's policy and that employer fires them, they will be discharged for just cause. Now, what this means is in many states that individual may not be eligible for pension, unemployment benefits, any type of workers' compensation. So this is just something to consider when formatting your policies. You know, even if you don't want to allow medical marijuana in your workplace and you have a very good employee and perhaps they get fired for failing a drug test, that might be an issue you want to look at because that individual would not be able to claim unemployment under those circumstances. Now, I'm going to run through a couple of states really quick. These are the pro-employer states. So if you hear your state here, make sure to make a quick note of it. Alaska, California, Colorado, Florida, Massachusetts, Michigan, Missouri, Montana, Nevada, New Jersey, New Mexico, North Dakota, Ohio, Oregon, Vermont, and Washington. Now, I want to address 3 of these states very briefly. New Jersey is currently a pro-employer state, but there is a bill going through the legislature that would make it a discrimination violation to discriminate against medical marijuana use. Nevada is also a pro-employer state, but over the past couple of days, I think maybe less than a week ago, Nevada became the first state to ban pre-employment drug testing. So while Nevada is in fact a pro-employer state, that is a consideration, and it effectively prevents you from making hiring decisions based on marijuana use. Now, I also want to focus a little bit on Florida specifically because I know that's a particular import to our members. And Florida contains an express statutory provision allowing employers to drug test, and it also specifically rejects the idea of creating a cause of action for wrongful termination based on an employee's use. Now, what that means is if you fire an employee in Florida for medical marijuana use, and Ohio has a similar system, they have no cause of action. They can't sue you. Now, that doesn't mean that you shouldn't look at your employment policy and make sure you're following procedures. If you violate your employment policy, they may be able to sue you for breach of contract. But firing someone alone for medical marijuana use in these states is not itself a reason for the person to sue you. Now, as we move to the second regime here, neutral, there are only a couple states here, but the basic premise is that a neutral state is essentially silent as to the issue of employer and employee rights. Hawaii and Maryland are the only ones that are completely silent on the issue that also have medical marijuana regimes. And because of the supremacy of federal law and the way that these laws kind of interact with each other at the state level and the fact that, of course, marijuana is illegal federally, a neutral state that's silent to the issue is, for all intents and purposes, a pro-employer state, as long as you have a strong employment policy that reflects your state's regime and describes carefully and clearly what employees are allowed to do with regards to medical marijuana. So now we get to pro-employee states. I find these particularly fascinating because they create protections for something that is illegal federally, which is very interesting. And, you know, someone's going to take this stuff to federal court one day and it's all going to get knocked down. But until that time arrives, you're going to spend a lot of time and expense litigating to get to that point. So from my perspective, you want to be aware of the rules so you don't even have to worry about that on the back end. So what makes something a pro-employee regime? Well, the first thing is an anti-discrimination provision. Pro-employee states tend to have very explicit anti-discrimination provisions and prevent employers from making hiring, firing, job switching, tenuring decisions, any type of transfer decisions based on medical marijuana usage. Now, this is particularly interesting because you may be saying, well, what if I operate in a warehouse? Or what if heavy machinery is involved? Or I occasionally require employees to perform manual labor or do physical tasks. Well, the anti-discrimination provisions still hold that you cannot alter job duties or make employment decisions based on use. But there are some caveats, as we will see shortly. Drug testing concessions. This one is also very, very interesting to me. Under pro-employee states, if an employee has marijuana in their system following an accident and you find this in a drug test, that alone is not a sufficient basis for firing. The employee must have marijuana rise to a certain level within their system for that to be the case. We'll discuss drug testing in detail later on and why this can be a more complicated issue than it first might appear, but there are allowed to be certain levels of marijuana, THC specifically, in individual systems in pro-employee states. Now, when I was talking about this with the anti-discrimination provisions, you know, there's obviously some issue here with not being able to move employees who could be a danger to themselves or others should they be marijuana users. So what the pro-employee states have is a exemption for federal and regulatory requirement carve-out. And every single state that is pro-employee has this carve-out. And what it essentially says that if allowing individuals to use medical marijuana, even consistent with state law, would violate federal law or federal regulations, you do not have to accommodate that medical marijuana use. So for people who are worried about, well, you know, the law strictly prohibits me or I can't do my job if I'm allowing people to use medical marijuana, there are specific carve-outs for you to avoid those issues. Pro-employee states with their anti-discrimination, drug testing concessions, and exemption provisions also apply not only to patients, the individuals who use medical marijuana, but to caregivers as well. Caregivers are individuals who, under the different regimes, can sign up to deliver medical marijuana to people within the state. To briefly discuss it, the pro-employee states include Arizona, Arkansas, Connecticut, Delaware, Illinois, Maine, Minnesota, New Hampshire, New York, Rhode Island, Utah, and West Virginia. And interestingly enough, in New York, medical marijuana usage also qualifies as a disability under the state disability law. So now let's start getting into the meat of things. Now that you know what your state's regime is and you know whether you're a pro-employer, pro-employee, or a neutral state, let's look at your initial considerations. The first thing you want is obviously to determine your goals. Now this may seem self-evident, but you need to sit down and determine, do I want to allow marijuana use in the workplace? Do I want to allow it for some individuals and not others? Do I want to permit CBD use but not marijuana use? Will I allow off-duty marijuana use? So the first thing you want to do is sit down, determine what your goals are, and determine what would best fit with your business's practices and what would help you achieve success. Then you want to consult with counsel to review your state-specific system. You know, you may have this wonderful idea in mind where you want to prohibit everyone from using marijuana completely. You want to have an entirely free, drug-free, clean workplace. But if your state has an anti-discrimination provision, that may not be feasible. So as you determine your goals, you need to make sure they congeal and actually can be used in accordance with your state system. Then you want to draft an employment policy that reflects your goals. I'm going to harp on this a million times, but this is the most important thing. Your employment policy must be clear and precise. It needs to be readable in layman's terms, and it needs to address every conceivable situation medical marijuana may appear at in your workplace without any room for subjective interpretation. You also want to consider insurance and drug testing mandates. Even in pro-employee states, there are typically carve-outs that say insurance is under no obligation to pay out for an accident occurring while an individual is under the influence of marijuana. So if your insurance, and by extension the drug testing procedures that they mandate, require you to test for medical marijuana, your employees should be made aware of this, and you should incorporate it into your employment policy in such a way that individuals who use medical marijuana are appraised that they may still get drug tested, so they can either try and obtain a different job position where this may not be the case, or work with you to find a different type of arrangement. Now, you also want to institute compliance procedures. It's not enough to write it down, and this is a huge thing in the call center and telemarketing space, as many people have to deal with on a daily basis. Auditing is king here. Instituting compliance procedures and best practices is not merely enough. You also must follow up and make sure that these are being carried out. Now, this doesn't just mean, internal or external auditing. This also means making sure that the appropriate department, such as HR, has a role over medical marijuana. This issue is big enough, important enough, that I think assigning it to a specific department or creating a specific advisory council or corporate regulatory body to examine it would probably be a best practice. Now, of course, all this information, all these steps should absolutely be written down in your employment policy. Any decision you make with regards to medical marijuana, you should ultimately stem from that employment policy. So let's talk a little bit about some of the operative laws that are going to come into place. Marijuana is illegal federally, but funnily enough, the federal laws are still going to impact how you do things. So the first one here, the Controlled Substances Act. This one isn't too much substance, but we need to discuss it a little bit just to understand where all these laws and regulations flow from. So the Controlled Substances Act establishes what I'm sure many people are familiar with just in colloquial terms, the schedule of drugs. You have, Schedule 1, 2, 3, 4, 5, etc. Interestingly enough, marijuana is a Schedule I drug, along with heroin and, well, actually, I think fentanyl is a Schedule II now because it has medical usage. But marijuana is currently a federal Schedule I drug, which means it has no medical benefit and is strictly prohibited even from research and studies. Now, there is one exception. There is a institute in Missouri, I believe, that performs tests on marijuana, but they're the only one. So the federal status of marijuana is one of complete illegality. And if you look at the federal schedule of drugs, it says marijuana and then in parentheses cannabis. So it is a broad swath. It does not say THC. It does not say CBD. It just says marijuana cannabis. However, I'm sure a lot of people have heard a lot about the 2018 Farm Bill signed into law by President Trump, I believe November last year. There was a lot of misinformation following passage of the 2018 Farm Bill, not the least of which was that CBD was now legal following its passage. And I know, at least in Ohio, for us, you could walk into a corner store and find them selling this stuff just over the counter, and they have this big sign to say, CBD is legal now, and then a couple weeks later, the state comes in and says, sorry, nope, still controlled substance, and they pull it. So is CBD legal? Well, the short answer is it depends, which I am sure everyone loves hearing from lawyers. But it is legal in certain circumstances. So the first thing that has to happen is your state has to submit a plan for approval by the federal government. Then you need licensed hemp cultivators in your state. Then CBD has to be produced. It's a derivative of hemp. It has to be produced from that hemp according to that plan and in accordance with state regulations. So CBD still is Schedule I drug for all intents and purposes, but it's legal if it is produced pursuant to an approved federal plan by a licensed hemp cultivator in accordance with state regulations. So it can be legal in very, very limited circumstances, and it would probably be a best practice if individuals in your office or workplace are using CBD to ensure that they're getting it from the right source. Like I said, a lot of corner shops sell it over the counter, not understanding that they're in fact violating federal law and federal drug trafficking laws. So now the Drug-Free Workplace Act. And the Drug-Free Workplace Act really stems from the CSA because the Drug-Free Workplace Act makes reference to schedules of drugs. Now, what the DFWPA requires is employers to maintain a zero-tolerance drug policy with regards to certain chemicals. Now, marijuana is a Schedule I drug is firmly included in this. So what this means is individuals who are under the purview of the Drug-Free Workplace Act, those who are federal contractors, those who receive grants from the federal government, you, as a condition of your contracts or your grants are required to maintain a drug-free workplace. Now, whether the federal government pursuant to your individual plan requires you to do regular drug testing or trusts you to do so is a matter of an ad hoc specific case-by-case basis. But in general, if you are subject to the purview of the Drug-Free Workplace Act, you cannot allow medical marijuana use in your business. Certain regulatory compliance measures as well, such as Department of Labor regulations for heavy machinery or Department of Transport or Transportation regulations for operators of public accommodation, you are also not allowed to use medical marijuana. Now, thankfully, since the audience today is individuals from call centers, I don't believe there will be too many federal contracts or grants. So the Americans with Disabilities Act, now this is a law that I'm sure many individuals are very intimately familiar with. And, you know, from a basic standpoint, the law says that you are not allowed to discriminate against individuals based on the status of their disability. Well, disability is a very broad term, so what exactly does this mean? You have to provide reasonable accommodations to such employees. So for instance, say an individual has, you know, carpal tunnel or something, you may have to give them a wrist strap to help provide support. Now, I'm sure a couple of people in the audience are thinking, well, the ADA, I'm very familiar with, it's a federal law. Marijuana is illegal federally. So how could the ADA possibly impact marijuana? And you'd be right at first glance. So medical marijuana and the ADA, we have a case here, Emerald Steel Fabricators, Inc. versus Boley out of Oregon. And the court pretty much held straight up that employers have no obligation to accommodate medical marijuana because the ADA does not apply to a person engaged in the use of illegal drugs. Now, if you look at the previous slide, if you remember, the CSA established marijuana as an illegal Schedule I drug. As an illegal Schedule I drug, it is not covered by the Americans with Disabilities Act. But be careful. I have been looking at some of the cases in this area, and I think this is an area of litigation that is going to explode very shortly. I think the courts are just waiting for the right case to come through. But while the ADA does not protect medical marijuana users, you must still operate to avoid the appearance of impropriety when dealing with medical marijuana users. For instance, if you fire a medical marijuana user who uses it for cancer, if you don't do it the right way, it sure as hell looks like you're firing that individual for the cancer and not the medical marijuana use. So while the ADA does not protect medical marijuana, it will in pretty much every situation protect the underlying condition that qualifies that individual for the marijuana use. So the most important thing here is to keep a documented record. If you want to fire a medical marijuana user, you want to transfer them, or you want to interact with them in some way, but want to avoid the appearance of impropriety with regards to their underlying condition, you absolutely need to follow proper procedure and protocol. Use the proper departments. If HR is responsible for these decisions, then the president of the company should not be doing it by himself. Look to your employment policies. What was the employee handbook that the employee signed? What procedures do they anticipate having to go to? If you want to administer drug tests, make sure not to discriminate. And if you're going to do a random test, it must be truly random. Or if you do a certain type of sequential testing, it must be that person's turn. You essentially cannot fire someone for the marijuana use without a proper record. Otherwise, it may appear as if you're firing them for the underlying condition. We've had a couple issues like this go to some of the courts already, and the courts have considered it firmly an ADA issue, and because marijuana is illegal, they've kicked the cases out. I am just waiting, and I've seen a couple courts start to entertain the idea where a case goes up, and they say, well, you know, this individual wasn't fired for the medical marijuana. It really was the underlying condition. Therefore, the ADA does apply. I think this is going to be a very heavy area of employment and medical marijuana litigation. And as fun as it would be to be ahead of the case law and make the law, I would not advise anyone here to do that. So you want to keep a very highly documented record using the proper employment policies and procedures with the appropriate individuals and departments. Make sure to substantiate any findings you have and make sure everything is done in accordance with proper procedure and protocol. Now, I'm sure a lot of people have questions about insurance too. This is perhaps the second biggest issue outside of some of the federal laws that we're looking at that I think people have to deal with on a daily basis. So, insurance policies generally, do they protect medical marijuana use? If an employee is injured or causes damage or harm to the business on the job, will an insurance policy protect them? Unfortunately, and I would say probably 90% of cases, the answer is no. So even if you want to permit medical marijuana use in your business, be aware that the insurance policies covering that employee probably aren't going to allow them to use medical marijuana or cover them for a payout. Now, this isn't necessarily a huge issue. Dealing with call centers, for instance, telemarketers are not going to be doing heavy lifting or using heavy machinery. So to the extent that you aren't worried about a workman's comp accident, for instance, this may not be applicable to you. Drug testing. This is another important thing because insurance policies, they don't say, oh, you've got marijuana in your system, you are not getting a payout. They require you to administer a drug test, and then if one of several preordained banned substances shows up on that drug test, then the individual is denied a payout. Some insurance policies may not require you to test for state legal drugs, those being marijuana. Some may also provide you a great amount of leeway in determining what drugs to test for specifically. So I've seen insurance policies, for instance, that say you must drug test individuals, but they leave open what exactly you have to drug test them for. That's a little bit of leeway, and if you can get a little bit of creativity going, you may be able to find a way to drug test medical marijuana employees, but not have them denied payouts for those purposes. Employment policies. We talked a little bit before about how employment policies should be clear and concise. That means that they should congeal with your insurance policy requirements. If there are inconsistencies between your insurance policy requirements and your employment policies, that will reflect poorly on you. State regulations. Even in pro-employee states, most state regulations have a carve-out for other contracts in general or insurance policies specifically. So even if your employee is, or even if you're in a state where the employee is more protected by anti-discrimination provisions than they would otherwise, you're still allowed to have the insurance or other contracts supersede those rights. Now, working with cannabis users, why would you want to do this? We'll discuss that in detail towards the end of the presentation, but there are some insurance companies who are kind of making their own little wheelhouse, if you will, offering and covering cannabis users. And they're developing specific actuarial mathematic tables and charts for this express purpose. So if you want to work with users, there are alternative insurance policies that will apply to them specifically. So drug testing. Understanding how drug testing works is very important as well. So just the basics, how do drug tests work? Well, in the case of marijuana, they will examine a sample of urine, blood, or hair to determine the exact concentration of THC in an individual's system. Now, there can be false positives. Marijuana is unique in that it is fat soluble, unlike a lot of other chemicals. What this means is that marijuana remains in an individual's system for an extended period of time, and it can remain in there anywhere from 2 weeks to 2 months, depending on the individual's age, lifestyle, factors such as those. Now, I'm sure a lot of people are wondering, well, what about CBD then? Does CBD show up on drug testing? This is a very big question, and it's very nuanced. If we have some questions about it later, I can get into greater detail. But CBD should not show up on a drug test. The issue is, however, is that a lot of CBD products contain minute amounts of THC. If you recall back to the beginning of the presentation, most states define CBD products as containing 0.3% or less THC. Well, 0.3% or less is not a lot, but it's greater than 0. And because marijuana is fat soluble, that THC can build up in an individual's system. What that means is an individual who uses CBD could in fact test positive on a THC marijuana test, even though they have not used THC products at any point in the past. So what are steps to an effective drug testing policy? Well, the first is consistency. You want to apply the drug testing policy amongst your employees equally. You don't want to single out users. You don't want to single out non-users. It needs to be administered fairly using the same personnel and the same procedures. Now, that is not necessarily to say you cannot have different drug testing policies for different classes of employees. Say you have a class of employees performing non-intensive, non-physical work that's not manual labor, that you think that these individuals could be using medical marijuana, you could have a different drug policy for them than you would other individuals. But the name of the game here is you still need to avoid the appearance of impropriety or unfairness. Individuals within those groups should still be treated the exact same. Awareness. Now, everyone's got those, workman's comp, workplace safety posters that you have to hang up and put around the office. I think your drug testing policy or your employment policy, if you want to incorporate it in, you should do something similar. The more aware you make people of your drug testing and employment policies with regards to marijuana, the less room they have to sue you when something goes wrong. If they're aware of it and they agree to it, and they see it every day, it's really hard for them to come back one day and say, well, I wasn't aware you're going to do this for me. So discharge. Now you want to determine your rights as an employer. This goes back to determining if you're a pro-employer, pro-employee, or a neutral state. Regardless of what state you're in, if you want to fire someone for medical marijuana use, and as we were talking about with the ADA to avoid the appearance of impropriety, you absolutely need a highly documented record. And we have the case here, Cotto versus Ardagh Glass, coming out of New Jersey. And the court essentially held here that the employer had supreme rights to fire an employee for medical marijuana usage, even though there were some protections in the state law. Most importantly, the law did not specifically require private employers to waive the drug tests for the medical marijuana users. When the employee in this case was administered a drug test, they of course failed and were properly discharged because the employer's supreme rights to administer drug tests as they want to. So now we finally get to employment policies, and I've said it before and I'll say it one last time for the people in the back, but this is the meat and potatoes of your medical marijuana stance for your business. This should be the source from which everything stems, because this is the document your employees are most likely to be familiar with. And when they have questions about their job, it's the first place they're going to go look. So your employment policy should have an incorporated medical marijuana, drug, privacy, whatever you want to call it, policy, referring to the individual employee's specific rights with regards to medical marijuana. Now the first thing here, clarity. Your employment policy absolutely must be in plain English with no room for subjective interpretation. It needs to be a what you see is what you get type thing. Employment policies are essentially contracts, so if this was to go to court, they would be using contract law. One of the principles of contract law is that a contract is to be construed strictly against its drafter, because the drafter, you're the one writing it, you have the ability to say what you want. If it wasn't clear, that's your fault. Well, the drafter in this case is going to be the employer, you. So there absolutely needs to be no room for ambiguity. There can't be any gray area in your employment policy. It needs to describe exactly what happens when, with whom, because if it goes to court and it gets brought in, it will be construed in favor of the other party as a rule of general interpretation. This leads directly into specificity. You need to be exactly specific about who is able to use medical marijuana, where, under what circumstances. Can they do it all the time? Are they restricted? Will you allow individuals to transfer job duties if they don't feel they can adequately perform while using medical marijuana? You should also make reference to your drug policies here. What exactly has a positive result, for instance? If you recall back to the beginning when we were discussing pro-employee states and some of the drug testing concessions, for instance, some of these drug tests in the pro-employee states allow you to have a minute amount of THC in your system and still not be discharged from that. So you need to state specifically what constitutes a positive result. You need to state specifically what job positions can use medical marijuana and which ones can't. And we'll talk about this at the very, very end, but you may also want to look at the distinction between THC and CBD and enumerate this within your policies. These two chemicals have very, very different effects, and I think it's a fair assessment to say that certain types of individuals would be able to function using CBD on their job, whereas they would not with THC. So looking at the job duties in combination with what these individuals are going to do is very important. State-specific regulations. So you also need to consider what your employment policy means in terms of what your state says. For instance, in Ohio, if you fire an individual for medical marijuana use and you prohibit it in your employment policy, as I mentioned before, that's a just cause discharge. Now, you may have wanted to get rid of the employee, but maybe you didn't want to deny them unemployment benefits. So looking at the interaction between what your employment policy says and what that says and what the state regulations say that mean and the effect that has on what you do with your employees is incredibly important. Be aware of the language in your employment policy and how this will be dictated and informed by the state regulations. Now, interaction with insurance and drug testing procedures. We talked about this in the previous slides, but the most important thing here is make sure your employment policy matches your insurance and drug testing policies. If they're inconsistent, if there is a discrepancy between them, that all of a sudden makes your employment policy look a lot weaker because it just can't be followed in all circumstances. I would say you should probably start with insurance policies in this respect because you don't want to offend your insurance carrier and you need to make sure that your employment policy comports to their requirements. But once you've gotten there and you've determined what you absolutely have to have in your employment policy, you can engage in a little bit of a subjective analysis, a little bit of leeway. But it absolutely must match the terms of your insurance and drug testing policies and should not contradict them. Job duties, we've talked about this a little bit, but individuals who are in safety-sensitive positions or those who operate heavy machinery or have the ability to potentially cause harm using any type of machinery to the business should, as a matter of best practices and policy, not be permitted to use medical marijuana or be under the influence of such while on the job. So we've talked a little bit throughout this about cannabidiol, CBD. And I felt that it was important to touch on it specifically because, as we near the end of the presentation, this is one of the most important areas. In fact, I would say this right up there with your employment policy, understanding what CBD is and how it works is of the utmost importance. So what is CBD? CBD is cannabidiol. It is one of the 113 some cannabinoids in the marijuana plant. It is composed of hydroxide, methyl, and propanidylene. I looked all those up on Wikipedia for all the people who were impressed. But the most important thing to note is that CBD differs from THC in very distinct manners. THC is notable because it has a psychoactive effect. It gives users the colloquial high that they will generally experience when using marijuana. CBD, however, does not produce that effect. It's been shown to be very useful for seizures, neurodegenerative disorders, gastrointestinal disorders, and certain forms of autism. And in fact, there is currently one CBD-approved drug by the FDA, Epidiolex, which is used to treat two specific and rare types of seizure disorder. So there are good reasons to want to allow CBD, even if you exclude THC. Now, as we look to some employment considerations, the first one is, of course, the employment policy. This should always be your first thing. We talked a bit about it on the previous slide, but creating a distinction between THC and CBD, I think would be a worthwhile venture. CBD products is a matter of course, and as a matter of course under state and federal regulations following the 2018 Farm Bill, cannot allow users to experience the high of the marijuana plant. So while they will contain 0.3% or less THC, this is not enough to cause an effect in the users. What this means is you can, for the most part, and assuming people are getting their CBD from reputable sources, you can trust individuals with CBD even if they operate in a little bit more of a labor-intensive environment or they have a little bit more sensitive job duties. Now, I'm not saying that you should allow someone who uses CBD to operate a forklift, for instance. I guarantee if they tested positive following that for marijuana, they would still be imposing liability and insurance would be denied and all that good stuff. But it is worth looking at creating separate employment policies for separate classes of employees depending on their job duties and the safety-sensitive nature of that position. Dealing with a call center, for instance, I think it would be much more appropriate to allow representatives to use CBD than THC. Now, whether a representative may be able to use THC is a case-by-case basis, but as I'm sure people are aware, one of the stigmas of marijuana is it causes a delayed reaction time, or it causes a slower ability to adapt to instant-by-instant change. In a call center where you're dealing with a lot of people on a very rapid basis, that's going to depend on the individual if they can handle the drug in a way that does not impede their ability. But CBD in that scenario, as a matter of course, would not cause those same deteriorative effects and would not impact the individual's job performance in such a way. Insurance and drug testing. Now, this is a very interesting area, and we talked about it briefly before, but drug tests from insurance companies and most marijuana drug tests in general will only test for THC. Ostensibly, an individual getting pure CBD, 100% CBD from an authorized hemp supplier would not test positive on a drug test. And you should make people aware of this in your employment policies if your stance is you do accept CBD, and if you don't, then there are specific CBD tests you can get that will also find this compound. What's important to note, though, is say you're in a situation where you permit CBD use, but you do not allow THC use, or perhaps you're dealing with a job where that's the case. It's important to note, and I brought this up before, but marijuana is fat soluble. That means depending on the individual's lifestyle choices, age, diet, exercise habits, it will leave their system quicker or faster than others. Because CBD contains a minute amount of THC, which is fat soluble, it will build up in the individual's body. Therefore, a CBD user who uses CBD every single day and nonetheless does not experience psychoactive effects may test positive on a drug test as the THC accumulates throughout the fat portions of their body. So even if your insurance drug testing policies allow individuals to use CBD or do not require specific testing for it, you should make individuals who are allowed to use it aware of the potential repercussions of its constant use and that they may still nonetheless test positive for THC even if they haven't used it recently. One of my favorite stories regarding this actually is Ohio. Ohio loves to say with regards to all of its marijuana products, it has never had a recall. And that's true. When Ohio found it had a couple of mislabeled products, it didn't recall them, it just held them. It put a hold on them. So Ohio hasn't had any recalls, but it's put holds on products. But what that goes to show is we're in a very nascent industry. This stuff is going to get mislabeled. You know, you might buy a CBD product that has more THC than you were anticipating, and that may reflect on drug tests. So employees need to be made aware of this, particularly since a lot of corner stores, like I mentioned, will be selling these products with incorrect labelings or percentages. And so we get to the final slide here, working with medical marijuana users. Why exactly would you want to do this? You know, we've talked about this and all the big scary things that can happen, and it's hard, and insurance may not accept it. Why would you want to do this? Well, from a very basic perspective, as Michelle noted, there are over 1 million medical marijuana eligible individuals in the United States. This is an issue that is only going to keep growing, and only more people are going to be qualified. If you don't allow medical marijuana use, some of your best people may leave. You want to prevent brain drain. You want to be welcoming of new individuals who are medical marijuana users who could contribute actively to your business, but may not be able to otherwise. One of my favorite analogies to this are Silicon Valley. Silicon Valley, of course, is located in California. It's responsible for a lot of the tech startups. They were actually the first industry to completely forego drug testing because everybody was testing positive and nobody was getting hired. The United States Army Corps of Engineers, who hire individuals to do drone piloting training and program, had to suspend marijuana drug testing because all these kids they were getting who were good at video games and good with this hand-eye coordination needed to operate the drone programs were all testing positive for marijuana. So there is good reason to work with medical marijuana users. A lot of these individuals are high-performing. And what's also important to note is that the qualifying conditions for medical marijuana use amongst the states are, they're pretty severe. They're things like cancer, they're things like fibromyalgia, autism, Crohn's disease. These are not simply headaches or colds that allow individuals to use medical marijuana. So in lieu of medical marijuana, if these individuals can't use it while on the job or off the job even, a lot of these people will resort to opioids, which have very similar effects and have a higher dependency rate than medical marijuana. So from a policy and from a kind of workplace camaraderie standpoint, it's certainly a positive so as not push people into other drugs that may be a little bit more dangerous to their job performance. You also have a little bit of a less concern in the medical arena because, like I mentioned, these individuals have legitimate conditions. The medical marijuana, in the same way that Adderall treats individuals with ADD, is not necessarily going to cause them a exuberance effect, but it will help return them to a baseline and manage their pain so they can work on the job more appropriately and effectively. Employment policy considerations for dealing with medical marijuana use, I want to harp on it one last time, clarity and specificity. You need to determine who can use marijuana, when, under what circumstances, for what job duties, and if it's a THC or CBD-based distinction. And finally, you want to look at job modifications when you're working with medical marijuana users. So, some individuals who operate forklifts or who are driving trucks, these are people who very clearly should not be able to be allowed THC-based medical marijuana use on the job. Now, what you could do with someone who qualifies in such a position, or someone who works in a warehouse or your stocking department, something like that, is you could transfer them to an equitable position with similar jobs or similar job duties, responsibilities, and pay rate, and kind of shift people around. Now, this is basically what we're seeing in a lot of states like Ohio that requires some attention to safety-sensitive job positions. But ultimately, like I noted, it stems from your employment policy. Your employment policy is the bedrock of all medical marijuana practices in your business. It's important that you have that down and tightened up so as to avoid any potential issues with litigation later on. And with that, that brings us to the end of the presentation. So if anybody has any questions, we would be, Michelle and myself, we would be happy, more than happy, in fact, to answer anything you might want to know.
Thanks so much, Chad. That was so informative. Lots of great information there. These slides will be available to PACE members on the PACE website, as will the audio. So if it's something you'd like to share within your company and with your HR folks, I would certainly encourage it. Chris or Casey, I don't know who's on the phone right now. Are there any questions that came in during the presentation?
Hi, this is Casey. I think we had a couple of questions, but they were so similar to these last couple of slides. I guess maybe one that Chad, you could maybe expand on a little bit. From an employer side, can I be found to have violated federal law if I knowingly allow a medical marijuana user to continue to work at my company?
Yeah, no, that's an interesting one. I'm sure everybody's worried if the feds are going to come after you. Well, rest assured the FTC is already doing that. But as it stands, simply being a business owner who permits medical marijuana use, even if you permit it on the premises, you're not giving the marijuana to them. You're not partaking it with them. You're not directly liable for that. If anyone was to get in trouble there, it would be the employee. But even then, the federal government started under Obama and it continued under Trump. The Rohrabacher-Farr Amendment prevents the allocation of any funds to the Department of Justice for the prosecution of state-compliant medical marijuana regimes. So what that means is the federal government is legally stopped, at least until the next budget, and I'm sure there will be another shutdown or something about it, but the government is legally stopped from going after legal medical marijuana businesses. If they can't go after them, they are sure not going to go after employers who are following the system as well. So I would say, as an employer allowing medical marijuana use, as long as it comports with your state system, you are not liable for allowing employees to use it.
Okay, thanks. Well, if anyone else has any questions, you can type them in that chat box, but I think we're about at the top of the hour now. So I'd really like to thank Chad and Michelle for all this great information. And if anyone does have questions that come up later, definitely let us know and we can pass that along. And like Michelle said, all this information will be available on our website. Just as a quick reminder, the PACE Washington Summit will be coming up in September in Washington, D.C., and registration and hotel reservations are now available on the website. And also, just as PACE members, please remember there are lots of benefits that you have as part of your membership. There are benchmark portal certifications, resource directory, et cetera. So please feel free to check those out on our website. We appreciate everyone's time and hope you have a great day. Thanks.
Thank you.